This is Moments of the Movement, Civil Rights and Change in America.
I'm Lonnie Bunch, founding director of the Smithsonian's National Museum of African American History and Culture. Welcome to Moments of the Movement. The courtroom was the ultimate battleground in the war for equal rights for all of American citizens. And among the names of African American lawyers who fought on this stage is that of Matthew J. Perry, Jr. Perry was the first African American lawyer from South Carolina to ascend to the federal bench, and the federal courthouse in Columbia now bears his name. But before all that, Perry was a young lawyer attempting to try cases in the Deep South, often before biased and racist judges.
After the war, I was discharged in January of 1946, and I returned to my native Columbia, South Carolina. And now I needed to complete my undergraduate college training. And so I had decided that I was going to return to my alma mater, South Carolina State College. I had to return in the fall, beginning September. But during the spring months, there came to trial two cases in the federal courts here in Columbia. And a couple of friends and I, also veterans of World War II, learned about the fact that these cases were about to be tried. They were getting a great amount of publicity. So we decided to come uptown to the court, not this building, of course. The building is now the home of the United States Bankruptcy Court, around there on Laurel Street, near Laurel and Assembly. And that's where the federal district court was. And so I went in, and I and others were spectators, and we saw these two cases tried back to back. One of them was the case of a black citizen named George Elmore, who had brought a suit on behalf of himself and others similarly situated against the election officials of South Carolina, challenging the fact that he and others similarly situated, meaning black Americans, were denied the right to vote in the Democratic primary elections. The Democratic Party of South Carolina and the Democratic Party in other states around certainly around the Deep South, operated what were known as white-only primaries. And Mr. Elmore and others were challenging this. By the way, the United States Supreme Court had already decided a couple of years before that in a famous case called Smith versus Allwright, that that practice, as practiced in Texas, was unlawful, that it was a denial of equal protection and a denial of the rights guaranteed under the 15th Amendment. And so that was the precedent. I did not then know about Smith versus Allwright, but I've later learned about its significance. But that was the basis upon which the case was fought in the district court here in South Carolina. They tried it, and of course the judge took it under advisement, later decided, of course, in favor of Mr. Elmore and others. But then, upon the conclusion of that case, the other case was tried. That was the case of a young black American named John Wrighton, who had applied for entry as a student in the law school at the University of South Carolina. And Mr. Wrighton, also represented by Thurgood Marshall and others, was suing for the right to enter the University of South Carolina's law school. Again, I was aware that I and other blacks could not attend the University of South Carolina. We had a black school. There were other black schools here, Benedict College and Allen University and Claflin, but South Carolina State College was the only state-supported institution. I couldn't get a job, certainly not as a law clerk. No government employment was offered me. In fact, no employment opportunities presented themselves. And so it became obvious that if it was going to be the law, that I was going to have to open a law office. I was born and reared in Columbia. That was home. I had relatives in Spartanburg, one of whom operated a rather successful funeral home establishment. And he and my mother conferred, and he suggested to my mother that it would be a good idea if I chose to come to Spartanburg. Spartanburg did not have any black attorneys. Columbia, by the way, had I think about 3 at the time. People just don't rush into the office of a very young, inexperienced lawyer. Certainly not a young, inexperienced black lawyer. White lawyers might fare just a slight bit better, but when you're young and inexperienced, you don't attract business. Now, this cousin of mine who had this business signed a bond of, in some way, got a person out of custody who had committed some traffic offense. Just a simple traffic offense. They'd go to the municipal court. So this was my first foray into a courtroom. And so I went, and there were lots of people, plenty of young lawyers also, of whom I was the only black. And the municipal judge, who was just a racist of the first order, received the other lawyers cordially. By the way, the extent of his authority and jurisdiction was, upon a finding of guilty, to impose a sentence that included either imprisonment for up to 30 days or a monetary fine of up to $100. That was the extent of his authority. And so, routinely, as these young white lawyers appeared before him, he was letting them off with a $10 fine or maybe $15 or just probation. Finally, when they called my case, I went forward. By the way, I had on my clean suit, my clean shirt. I had my briefcase that my wife had given me for graduation. Didn't have a thing in it but a pad. And I went forward and stood before him. There wasn't a prosecuting attorney. The police officers normally did their own prosecuting. So he looked up at me and he said, "Yeah, what you want?" I said, "Well, Your Honor, I'm Matthew Perry. I'm an attorney here to represent Mr. Such and such." So he looked with a frown on his face, and without affording me an opportunity to present evidence on behalf of my client, he announced that he found my client guilty and imposed a sentence of 30 days or a fine of $100. by comparison, you see, with what he had been doing. Well, I was crushed because of the unfairness of but what could I do about it? You can imagine that didn't do anything for my reputation. Who would want to hire a young lawyer who got that kind of result at the municipal court? It took quite a while for me to get another case. And the next time I went over there, something similar happened. And so on a third time, sometimes later, by this time I had learned. You see, in law school, you don't really learn how to operate in courts. Back at that time. Now, in today's law school trainings, much of this is imparted to students in clinical courses, but not then. Certainly not in our law school. To appeal from a decision of the municipal court, you had to file your appeal within 5 days. The appeal was from the municipal court to the circuit court of the county, and from an adverse decision there to the state Supreme Court. So the circuit judges had appellate rights over the decisions of municipal courts and also magistrates' courts. But you had to serve a notice of appeal, and your notice had to contain your exceptions, the grounds on which you were going to appeal. Well, I had, come upon this idea. If you're going to exist here, you've got to find a way to get around this judge. And so I learned how to draft a notice of appeal. And so I had drafted the notice of appeal for use, and when the case came, I put the name of the client on it. And of course, very simply, I had some grounds that the decision was not based upon evidence, was contrary to the evidence presented, words of that sort. I forget what other ground I laid out in there, but it was a good ground. And so when I appeared before him, he tried the same thing. And when he did, I opened my briefcase, still brand new briefcase, pulled out my notice of appeal, laid it before him. By the way, it had to be served upon the municipal judge. He had to acknowledge receipt of it. And I said, Your Honor, would you please accept service of this notice of appeal? So he was shocked. He looked up at me and he says, What is this? How did you know what my decision was going to be? I said, Your Honor, this has been your decision every time I've come here. No doubt in my mind. So I went up to the circuit judge and I got him reversed. Now the next time I appeared, the reception was somewhat different.
Oral histories were conducted by the Southern Oral History Program in the Center for the Study of the American South at the University of North Carolina at Chapel Hill on behalf of the Smithsonian National Museum of African American History and Culture and the Library of Congress. Moments of the Movement, Civil Rights, and Change in America comes to you from New Visions, New Voices, expanding the American conversation because it's time to hear the difference. With support from the Corporation for Public Broadcasting. Visit us online at newvisionsnewvoices.org.